Ben,
Okay.
it's all yours.
Okay. Thank you, everyone, for joining us. And here, let me turn on the the screen slideshow from the start. Okay. Charles, thank you for hosting this as a part of South Florida Hospital News and the educational program that you bring to the local healthcare community. And I also want to thank Broward County Medical Association for being a part sponsor in this, in helping get the word out as to what we bring to everyone. And just before we get started, I just kind of wanted to give you an idea of where how this particular program come about. This is about our third year or fourth year doing this. I think this is the end of our third year right
And
now,
the into the
and that
third year, yes, into the third year.
end of the third year that we're doing this, and how to handle collection challenges for working with health plans. This is probably our second repeat of it. We last did this about 18 months ago, but things have changed since then, and new things have been introduced. So I kind of wanted to touch on that, as well as bring everybody up to speed. Like Charles said, I am currently speaking from Sedona, Arizona. Here's a map for those of you. There's the blue dot, and that's roughly where I'm sitting. And this is what my outside looks like. It's a beautiful place. The temperature here is about 62 degrees in the daytime and about 40 mid 40s at night. So, so with that said, just by way of brief background, I am a healthcare attorney. I was formerly a certified public accountant. I have multiple degrees, and I happen to collect them like people collect, I guess, some sort of a coin collection or a stamp collection. But I've got multiple degrees and some certificates that are probably not even on this. But really, for your purposes, just know that I do have a pretty serious discipline in finance as well as legal. I've Being a former CPA, I think lets me kind of figure out how cash flows work, how accounts receivables work, and what is a realizable receivable or not. And today we're going to be kind of talking from the vantage point of administrators who are responsible for handling receivables and combining it with the with the legal knowledge of what an attorney like me would perhaps would want to impart on you, if you and I spoke one on one about healthcare receivables. I've worked inside large size healthcare systems, large size law firms. I started my own law firm about 4 years ago now, and there's been no looking back. I've been fortunate to actually grow my business in a pretty nice way. I have several other colleagues, and we all work together in helping our healthcare clients. Like Charles said earlier, this is our firm is actually physician centric, so meaning that we primarily cater to medical groups and physicianpreneurs. So for today's purposes, it's this webinar is intended for really healthcare CFO types, like financial individuals or administrators, people who are responsible for the revenue cycle management of their business, and for physicianpreneurs. The reason why this topic is so serious is because you can actually lose your right to bring forth claims. I recently had an issue that came up. There was about $500,000 that was owed to this one particular entity by one specific health plan. And part of it was because they did not make the claims and appeals on time, they lost about $200,000 of it. Even by the time they got to me, it was already too late for that. However, we pushed it forward anyways, and it was about $300,000 we ended up recovering. And so anyway, with that said, just know that today what we're going to be talking about is it is time sensitive. It does require special attention, and it's just an important topic when it comes to medical groups. Keep in mind, today's presentation is for general information purposes only. It is not legal advice. This seminar is an open and live forum, and it is being recorded. So if you have a question that is of general nature, please do ask it as we go along. But if you have something very specific and identifiable to you specifically, let's hold off till we actually turn off the actual recording, and then you can ask your very specific sort of a question. But otherwise, please do ask questions as we go through this process. And questions make it a lot easier for me to speak. It's a little bit harder being also on a Zoom medium. The interaction gets to be a lot less, and I would much rather do this in person anyways, because it just feels a lot more natural when we do. And it's much easier to ask questions and answer questions. So let's start off with market forces. So what's really at play here? It doesn't take a financial genius to understand that whatever you do not collect off the street, you actually lose it as a part of your net profit. And what I mean by that is, if you are owed $1 from a single institution and you've already performed the services, and that's why you have a receivable from that institution, you have not only lost out on the revenue, but you've also failed to get reimbursed for any of the expenses that that particular activity took up. So the real market forces here is, for every dollar that you do not pick up off the street from your collections, from your receivables, you lose it by ways of profit. It's not even revenues. You're actually looking at net profit. Same way on the opposite side, if you flip it, the way the insurance companies look at it is, for every dollar that they save in not paying out a provider is a dollar that drops to their bottom line and to their profitability. So it becomes a real tug of war. Both sides are pulling and stretching it, and it's a issue that's worth talking about, especially in this day and age, as DRG codes and reimbursement rates become more and more competitive. So today's presentation is really going to be on a four-part presentation. Number one, we're going to talk about why do health plans not pay, and that's going to help set up the stage for what we're going to go through next. Then we'll talk about what can a provider do about getting paid. And we'll spend a fair amount of time on that. Then we'll talk about what can you do if you are out of network and you get denied your claims? What are your options as a provider? As you know, it becomes more and more important because South Florida is a high tourism area. You probably do see a fair amount of out of network claims that get denied. So what can be done in the end if all collection efforts fail? And we'll talk a little bit about that, so your eyes are open if and when you decide to do anything else about it, and proceed forward. So why do health plans not pay? Well, there's several reasons, and here's just a few of them. One is they may consider your particular treatment that you provided a patient to not be necessary, that it was not really a life-threatening situation, that you weren't really, alleviating pain or alleviating illness, that it was not a medically necessary treatment. There's also the emergency medical care, meaning like it maybe some sort of a treatment that you gave to a patient was not really an emergent medical need. It was just a medical need that could have probably been looked at some point later in time, but it was not an emergency need. The other thing could be that your site of service, meaning like especially this happens under like hospital settings. If somebody goes in to go get a regular checkup in a hospital setting, a insurance plan may deny that payment because they're getting a regular checkup in a hospital setting, which is a much more costly site of service as compared to getting it at a regular doctor's office. So that in and of itself might be grounds for those kinds of services. The other thing is the enrollee information. The enrollee cannot be verified with the insurance company, and therefore they're not eligible to actually receive any sort of a benefit. Another reason could be that the provider themselves, meaning the healthcare physician practice, is not on the insurance network, so they could be denied the claim. And then last but not least, which we're also going to talk about a little bit later on in more depth, is that the provider is out of network. So how does all this happen? Well, and what can you do about it, right? So first of all, let's talk a little bit about a slight bit of preventative measures before you go down that road. What you need to keep in mind is that um, when it comes to dispute resolutions with health plans, it's really like a three-staging sort of a stepped up process. Number one, there's actually internal administrative things that could be done between you and the health plan, and you've got to go through that full process. Number two, some plans have this, other plans don't, that there could be conciliatory steps that you can take, meaning that they're non-binding steps, but you can actually introduce other parties, other contractors that help you resolve that dispute between you and a health plan. And last but not least, there is binding arbitration or litigation that you can enter into. And that's obviously a much more costly experience. However, it's the ultimate hammer to getting paid what you need to get paid. Now, internal administrative determinations or appeals, like this whole internal process, is usually it has to be expended, utilized, tapped into before you can escalate the matter to a higher and higher level. And then when you're negotiating this, you may want to consider putting the number of days and requirements that each side has to volley the claim, deny the claim. How many days will you have? How many days for appeal will you have? And up front, when you are negotiating these health plans, it is a good time to negotiate those number of days as to what would be appropriate. Now, most hello, yeah, can you hear me? Hello. Okay, sorry about that, guys. I don't know if you heard me on this part, but we just have to make sure that the administrative appeals process internal to the health plan is all exhausted before we go to the outside world and start looking for binding arbitration and litigation. So now, when you are negotiating a contract, keep in mind and pay attention to who will resolve this dispute. Meaning, will it be an independent dispute resolution entity or a court or some sort of an arbitration arm? Meaning, like the AAA, meaning the American Arbitration Association, or the American Healthcare Lawyers Association. There are many different avenues that you can use that will help resolve these disputes. When the dispute resolution process begins, will it be conducted in stages? Like, will there be a first level of submission? Will there be a denial? Will there be an internal appeals process? Will there be a mediation or an arbitration? Or do you just proceed to court if it gets denied? So that's a whole internal staging of the process that we had just started to talk about. Keep in mind that there will be alternative dispute resolutions in most healthcare plans. I have yet to see one that did not have it in there, but I have. It's been a long time that I saw one that did not. So I can't think of one in my recent days that did not have an alternative dispute resolution provision. So before you go into an alternative dispute resolution provision, you also want to look not only inside of the contract, but to the outside of the contract. You want to take a look at what sort of provisions are in the contract about tapping into payer provider manuals, payers' websites. What information is the contract giving you right on its face that you can follow? And if all else fails on that end, keep in mind you can always move towards federal and state laws that apply and tap into those as well. So the contract is a is an agreement which can allow you to opt out of certain statutes as well, which is what a lot of insurance health plans do try to do. They try to get you to opt out of these automatic statutory provisions that sit out there and get you into a private setting. And why do they do that? Well, they do that because They want to keep the matter confidential. They don't want their name, or let alone any other private HIPAA information and all that sort of stuff getting out, which that obviously wouldn't, but still they want to keep their name out of the limelight. And so you don't really know how much contracts are getting litigated, disputed, or arbitrated upon in the private, when it comes to these big healthcare plan providers. Now, what can a provider do about staging of options? Well, it's all about escalating the issues, right? So, in my mind, this is basically the 8-part process that I look at, and we're going to touch on this in a little bit more detail as we go through it. But remember, you're always starting off with the contract provisions. You're going to look at the internal administrative resolutions. What is allowed under the contract? Then what you're going to do is, if there is nothing specific in the contract itself, what you want to do is you want to look towards the outside, like to the payer provider manual. A lot of health plans do have a payer provider manual, which gives you the whole process of how to go about disputing and appealing a claim which has been denied. If they don't have that, you could even turn to the payer website. And this really comes in handy when you're out of network. So you know what the payer website says if you are out of network. So those first 3 things there are really the softer side of making claims or disputing a denied claim that has not been paid by the insurance provider. Step number 4 is really about following up on mediation or arbitration, but that's obviously going to depend on what's in the contract provision. So that may or may not happen. The next thing that you'll see is that you will have the state of Florida. You can always make a breach of contract claim against the health plan. And very few people tap into this, but do know that there's a Florida statute, and I've cited it on here, and you may want to take a picture of this, and I'll mention it later on in this presentation. Florida statute 641.3155, which is very specific to health plans and HMOs. And it has some very strict guidelines on what the health plans are required to do each time they have a dispute regarding a claim. Now, also keep in mind that there are other federal laws like the Affordable Care Act provisions and the No Surprises Act. They have their own rules and laws that you can tap into. There's even the ERISA laws that if you are dealing with employee health plans, that you may be able to tap into and gain recovery by tapping into the ERISA statutes under the federal law to claim your receivables against the health plan. Now, step 1, what you're obviously going to do is you're going to go into early dispute resolution option. And this is where number 1, what I always do is I start off with reading the contract. What does it say in the contract? What do I need to do? What are the minimum requirements? If what I'm looking for is not in the contract, the next thing I do is I go to the payer provider manual, and then I follow the process there. Let's say that I can't find it there, then I will also go to the website on how to submit a claim and how to go about disputing a claim and so forth. So you'll find sometimes things on the website as well, although they're harder to find on a website, but it's still an avenue that you should explore, and I explore it every single time before I proceed forward. Now, when you're reading these documents, look for the notice requirements and the provisions that allow you to further dispute the claim, whether you're internally disputing the matter or even before you go outside to the outside world before you file a lawsuit. So in this phase 1, it's absolutely important that you follow and read up on what the laid out process is for you to go through. A lot of people will read the contract, but not necessarily. They'll just kind of like call up maybe the claims desk at the health plan and start their process there. I typically start from the contract and then I work my way into the organization and ask them for payment. But I always like to know what my contractual obligations are before I go in, because they may be making me do more things than I need to do in order to make a claim. So it's really important to read that contract. Now, in phase 2, that's where really the dispute resolution provisions in the contract kick in. So this is past the point of where your claim gets denied, you appeal it back with a health plan again, and then it gets denied. Then what do you do, right? So what you may be required to do there is you may be required to mediate or arbitrate that dispute before you take it any further into court. And I mean, before you do that, what you want to make sure is you've read through all of your legal notice requirements and make sure that the arbitration and mediation requirements that they're asking you for, whether you go with like AAA, which is the American Arbitration Association, or the American Health Lawyers Association, and then there's even one called JAMS, and there's a few others as well. But these are the three most common arbitration associations that I come across. So I put them on there. So if that's what's being required, first understand that process, because each health plan has its own process. They're not all alike. They are somewhat unique in their own way. However, if you have no further steps available to you in the actual health plan itself, now you're going to have to proceed to court after that. So that's what you would do. So before we proceed to court, let's talk a little bit more about what Florida has allows. So under Florida law and as well as federal statute, you can always bring forward a breach of contract claim against the payer, where the payer has not paid you based on you having performed services. There could even be like an unjust enrichment claim. And I always make sure, and before I proceed to court, that I've sent out a last and final demand for payment, because that's where I kind of shore up that all of my paperwork is nice and tight. I've got all my paperwork in a row, my spreadsheets laid out nicely. I've got explanations as to what happened with the claims, and that's when I will actually proceed to court. So you got to make sure that this step two in here, that sending out a final demand letter for resolution. Before you do that, all of your I's have been dotted and your T's have been crossed, because you've got to have followed the internal processes. So, what does Florida statute allow? Well, there is what's called the Florida Prompt Payment Statute. It's section 641.3155, and it also corresponds with the No Surprises Act, and that has its own process. But what they basically say is that within 20 days of making a claim, it should be denied, paid or denied by the health plan. And if it's not, it's deemed to be accepted. But usually they will deny it within 20 days. So what'll happen is you can then appeal it. And those appeals, the provider has to file the additional information that they're asking for within 35 days. That's what the statute says, and the payer must pay or deny within 90 days of that. After 120 days of receipt, it is deemed uncontested, and the obligation to pay is absolute, unless if it's denied. So, there's some very black and white issues here. I have triggered those before just by making my claims and my notices, and then the payer is not paying. So again, you'll end up negotiating with them eventually anyways, but it gives you a bigger and bigger end of the stick if you follow Florida statute 641. Now, your ultimate cleanup through this whole appeals process and going back and forth will be litigation. Now, according to the statute, it also says that your lawsuits must be brought within 12 months after the plan's partial payment of the claim if they didn't pay you in full. And even if you write off the receivable on your books, you still have the right to go and make that collection claim. And that's how you would go about claiming it. This is a very powerful statute in Florida, and very few people actually take advantage of that. And this is something I like to tap into, because I don't think I mentioned this earlier, but I've probably litigated close to 1,700 cases before, and I don't hesitate to tap into the Florida statutes that gives me a right to step into court. So the quicker I can get somebody defaulted out, I will send them notices. I will send it to them FedEx, email, however many ways I can, to box them into a corner, to show them that, hey, I sent you notices, you failed to reply. I sent you second notices, you failed to reply. Not only did I send it to your billing department, but I sent it to your appeals department. Not only did I send it to your appeals department, but I sent it to your registered agent at the state of Florida, and nobody replied to me. And when they don't do that and they don't respond within their time, you're starting to gain the bigger and bigger end of the stick. And that's kind of how I take care of my claims, only because a I think litigation is probably the best way to teach others a lesson. And that's not to say that I'm lawsuit happy. I just think that when you have a situation like this, where it's, when it's like David and Goliath, you're dealing with such a Goliath of an entity. You've got to take them to court, and if you don't, without it, they just kind of like ignore you. And that's what a lot of my clients have felt in the past, and I think they do that. There's some level of intention behind it. I can't put my finger on it, but I think that there is some level of them denying the claims almost intentionally, if not making the requirements to file a claim so much higher and so much more specific that it just exhausts everybody in the process. And then the providers give up on making the claim. So this is a really good statute, well worth looking at, reading, tapping into. And if you have any questions about it, call me. We can walk through your situation and discuss it in private, or you can ask your general questions here. Okay, before I proceed, any other questions? Any questions at this time? All right. Now let's talk about out of network claims. So, what to do when there is no contract between a provider and a payer? So, when there is no contract, it's deemed to be out of network, right? So why is there no contract? Well, there may be several reasons. It might be because the patient is out of their normally covered region where they're supposed to be. So that means that they're out of the payer's network. So, like for example, Florida being a tourist state, there may be patients that you receive that are out of their network because they happen to be up in Pennsylvania or Illinois, and they're out of their network, but they happen to be down here in Florida, and their network doesn't stretch all the way down here. So that's a pretty obvious one. But then you could have it where the payer has restricted its network and has excluded the provider from joining that network. That happens too. So so some of these networks are closed after a while, and for new providers to join them, it's pretty difficult. Um, it could also be that the patient has chosen to obtain services out of the network. So maybe that's why it got denied. Maybe because the provider has decided that it is more advantageous to not accept payers' contract terms. And we'll touch on this last one a little bit more. Why is it more advantageous, right? Think about that for a little bit. Why would it be more advantageous for a provider to be off contract versus being on contract? And that's because there are other avenues available to them other than being on contract to make a claim against the insurance carrier, against the insurance health plan. So, out of network claims is definitely alive and well in this day and age. But what do you do to really shore up your right if you're out of network? Well, first and foremost, what you might see bolded and underlined on this slide is an assignment of benefit. That is something you absolutely need in order for you to proceed against the payer as if you're in the shoes of the patient. And that gives you, the provider, the standing to sue that health plan or that payer. And that assignment of benefit is generally obtained at the time of check-in when the checking in paperwork is being signed off by the patient. That's when you want to get the assignment of benefit so you can actually have the right to proceed against the health plan. Now, if it is a employer-based plan, there may be a plan administrator, and the plan administrator is required to comply with their plan terms and pay it accordingly. And that means that it would be under ERISA, and under ERISA, if you still don't get paid, then you just have to bring forward your claim to federal court, and that's how you end up fighting it. But if it's a non-ERISA claim, the providers typically bring the claim under a breach of contract claim in state court. So, like There is a employee health benefits claim that you can make by getting the assignment of benefit, or you can make it as if you're a aggrieved party that's owed money and bring it in a state court action. Now, I don't know if many of you knew this, but under the Affordable Care Act, there is a floor amount that is set for emergency services. And that floor amount is one of three things, and it'll be the higher of these three things. Number one, it'd be whatever amount is listed in Medicare Part A or B amounts, like what is the actual amount paid under Medicare Part A or Part B. So that's one option. The other option to look at is what is a payer's median rate for out-of-network providers. So if that's higher than what the Medicare rate is, then you would be entitled to that. And then if the plan has some other method of setting payments, that's your third option. So why do providers sometimes not join health plans? Because they find out that this is actually more lucrative to under the Affordable Care Act to get paid than it would be to have contracted with that health plan. So that's what they do. They will actually fall under one of these sorts of situations and make a claim for it. So remember, they are entitled to the higher of these amounts of one of these three things. So you might want to take a picture of that. If you have any questions, you can call me on it. Okay, now let's talk a little bit about the Medicare appeals process, and I'll go through this briefly because it's highly technical, but I broke it down and I summarized it as nicely as I could into a process here. There are roughly 6 steps that I have identified as the way your Medicare appeals process works. Number one, once you submit the claim, Medicare will send you a Medicare summary notice that says that your claim has been denied, and it'll typically have in it a reason for why you have been denied that claim. Then what you have is the right to appeal. You can ask for a redetermination, and this is all done by paper, and I think it's still done by paper even as of this year. Even though there's no physical appearance required, they have 120 days. There is a 120-day limitation to submitting that redetermination to a CMS contractor. Now, let's say that the CMS contractor also denies that claim to a healthcare provider, then the healthcare provider can ask for a redetermination of the contractor's decision by a qualified independent review contractor. So, which is yet a another entity outside of that process, and they're deemed to be independent. And for that, there's about 180 days from the first redetermination decision that was made. So as you can see, it's about a 6 part process. You can even make it up to the hearings in front of a administrative law judge. There is a review of appeals counsel, like a Medicare appeals counsel sits on these matters as well. I've underlined all of these days limitations, and you got to follow this process closely. And ultimately, what you'll have is the right to bring your claim in court. And if you have a Medicare claim, it's brought in before the federal U.S. District Court. So it'll be a federal cause of action. And again, there's a time limitation there that you only have 60 days from when the Medicare Appeals Council denies that claim to file a suit over it. So what if all collection efforts
Ben, I have a
fail
question.
altogether?
Ben, I have a question
Yes.
for you.
Sure.
With all of these claims, going after claims, it gets expensive. I would assume using an attorney to deal with this. Are they required, if you get a judgment against them, to also cover attorney's fees?
Yeah, like for example, that Florida statute has the attorney's fees provision in it. The federal statute, I haven't read it in a while, but I think that one does as well. So those all have it. The contract provisions, I'll tell you, in these health plans typically don't have it, and the insurance carriers or the health plans intentionally leave those provisions out of it. So there's ways to actually trigger attorney's fees onto the health plan should they be wrongly denying a claim. So there's other ways to do it. Yeah. So the answer is yes. It's possible to claim attorney's fees against those health plans, but they always try to wiggle out of them. So you got to read the contracts carefully, then you got to trigger the statutes the right way so that then you pretty much square them up so that they're responsible for the attorney's fees on that claim.
Okay, great,
Does that
thanks.
make sense?
Yep.
Okay,
I have a quick question. I'm sorry.
sure.
My question is that I'm in a specialty that uses a lot of third-party administrators. So for example, Humana, we don't contract directly through Humana, but through a different third-party administrator, obviously that administers the claims and all that type of processing involved with the claims. Your guidance applies equally to third-party administrators, or is that a lost cause in terms of
The third-party administrators will typically ask me to go and pursue it on behalf of the medical group that I represent. That's how I've done it in the past. Does that make sense to you, what I just said? Or is your situation a little bit different than what I just said?
No, it makes sense. But so if I have
Okay.
a grievance or a claim that hasn't been paid, do I start the
Right.
process through the third-party administrator and say, hey, you guys haven't paid this claim, I'm disputing this claim that should have been paid, or does that happen directly with the insurance company, in this case, Humana?
So a lot of third-party administrators will have their own departments set up where they will appeal that claim on your behalf. I like that to be exhausted before you go and contact your attorney on something. You know, did
Got
that
it.
answer your question,
Yeah,
Jamie?
yes, it did. Thank you, Ben.
Okay, yeah. So go, get as much of this done through your billing folks as possible. You don't want to reach out to an attorney immediately or quickly because that's going to frustrate you. It's going to frustrate your health plan, and it's going to frustrate the attorney as well. So you don't want to reach. So by no means am I saying reach out to your attorney. What I'm saying is exhaust the internal processes that are laid out first. Engage your billing team into that process and have them go and track these claims and see what's getting denied, why is it getting denied, and then make sure that you have that feedback loop created so that the billing folks are talking to your operational folks and the operational folks are talking to your providers so that you're coding things the right way, putting in the right things that need to be in the actual file so you can make so your claims get approved. It may be simply that you might be overlooking something that's very trivial and it's just not making its way into the file, and that's why your claim got denied. And if that's happening repetitively, that's probably because you're lacking something in the process. So most of the better billers that I know of or better run organizations, they will track like basically like a denial log. And in that denial log, they'll put down what was denied, what was the code, all of the specifics of it, and what happened and what was done to correct it. And if for nothing else, you got to figure out maybe you're just billing it the wrong way, and you got to reconfigure the way you're billing it altogether. Maybe it was just not the way you should have been doing it, from the beginning. So it's really important to actually have that denial log, especially if you're getting a fair amount that are being denied. There are some providers out there, like for example, the folks that like deal with like cancer medication sort of stuff, like oncologists. They will have really large size claims that sit there dead on their books for a long time. And those kinds of claims end up being because it usually involves some level of chemotherapy or specialty sort of medications that are being administered to the patient, or therapies that are going through it. They're really expensive therapies, expensive medications, and it's more than just like what a primary care person would see. And their claims could be really big and heavy. So it's important to have a really well put together quality improvement plan that's always monitoring and checking how your claims are going. So just to kind of, so now since let me just back up. So now what do you do when all collection efforts have failed, right? So what I always do is I make sure I revisit everything from the beginning. I make sure that all of my pre-filing a lawsuit requirements are fulfilled. I want to make sure that whoever I was supposed to reach out to resolve that dispute has been reached out to. I figure out where my location is for filing that particular dispute. Whether, did I do it the right way? Did I send it to the right address? I being my clients? Okay, so I being my clients, I make sure that all of that process is followed the right way. And if it is, then I will proceed to an actual filing of a lawsuit or entering into arbitration. But if that hasn't been followed, I need to really understand why it wasn't followed or what was done as perhaps a mitigating measure to get around that or through that. So I make sure that these dispute resolution provisions of the health plan are followed to the T as much as possible to the nth degree. So once you do that, then what you do is you have to then figure out who you're going to retain as your collections counsel, and you've got to designate an AR coordinator. If you decide to proceed to court, having a collections counsel in and of itself is not enough. Internally, or maybe perhaps your billing partner, whoever your billing entity is, like what Jamie was saying, maybe a third party processing entity, you need to have a billing coordinator in there working with your legal counsel to coordinate all of the information, because what I do in court is very different than what the AR person does internally, among those spreadsheets, among the HICFA form, 1500, as well as I think it's called the UB82 report if it's submitted electronically. So all of those things have to be complied with, but you got to get your team put together. And when I go to litigate, I also bring on another person with me. He's actually my trial attorney, and what he does is he does trials. So I don't go into court unless I'm ready to proceed to trial. And I want to make sure that I've got everybody geared up, aligned, and headed in the right direction. Because on the other side, what the health plans do is they will put up a good size legal team against you. They will hire usually a pretty much of a bigger, badder law firm than you probably will have. So I like to make sure that my ducks are all in a row, because when I stand in front of a judge, I've got to be sharper, smarter, faster, understand the finances of it, of what lies underneath, better than my opposing counsel. And, that's where I think my CPA background, my finance background comes into play, just because I think I tend to do that better than what most other folks do. But anyway, so what you do is you review the contract, you go through the actual prerequisites, make sure that they've been taken care of. If they haven't been, make sure that they're all tidied up. Then what I do is I send out a legal demand notice, and I usually send it return receipt certified, FedEx, however you want to call it, and I'll double and triple mail it. I will send it by regular mail, I will send it by email, I will send it by return receipt registered mail. Then usually the insurance company goes out and contacts their own attorney, and they try to resolve the claim with you, but they still kick you around for a while. They don't really give you straight answers. At least that's been my experience. And that's when I will file a alternative dispute resolution claim, or I will file something before the state court. And that's kind of how I proceed. Now, keep in mind, Florida Statute 641.3155 puts a 12-month limitation to submitting and appealing and putting forth these disputes from the date of denial, right? So if you have a clear date of denial, you got to make sure that you're bringing forward these disputes in a timely manner, or else you're going to lose the right to make that claim. So I look for, so I do get claims that are a few years old. However, I look for the files to make sure that I've got a clear denial. If it's not a clear denial, like what we had talked about earlier, it's deemed admitted, right? It's deemed to be admitted and it should have been paid. So if there's not a clear denial that's in the file, I will presume that it was never denied. So I go ahead and I proceed forward with it. Now, I know I'm riding the edge on that when I do that, but at the same time, it's the only way you're going to push through and get back the monies that you were never paid years ago. And usually we are able to make some sort of headway in that. And that's pretty much how you put forth a claim. That's what you do. You just go to proceed to court. Now, your next question might be, well, how long does a claim take? Well, it could really be short and it could really be long. So on the shorter side of things, it could stop pretty much anywhere along the way once the health plan comes to their senses. But if they don't come to their senses, how long will it go on for? So what I can tell you is, like, I just mapped it out on year 1 and year 2. You can see on this, year 1 is up top is year 1, year 2 is down here on the bottom. You can start off with filing the claim with the health plan. Then once you file the claim, and it's denied, you have to file the claim with their disputes department typically. Then you have to correct the error and refile it again. So you could spend several months going back and forth. This is the part of the process that I don't want to get involved in, only because your medical biller would be much more faster, quicker, accurate than I could ever be. And I don't think any lawyer should be getting involved in that first 4 steps where it's all kind of beige, peachish looking over here. I don't think any attorney should be getting involved in this part of the process. However, it's good to start talking to an attorney in these stages, because the next step is going to be the attorney is going to help guide you through making sure that you followed those steps of the contract correctly. And if for nothing else, there'll be a second set of ears for you to talk to. Then here in the blue, you'll see, like, you send out a legal notice. You send out while you will be sending information to your legal counsel. They'll need a few days to actually turn that around and serve a legal demand notice on the insurance plan. And then you actually file the lawsuit, then you serve the lawsuit, then you go through all of these preliminary steps. So if right now you are in the middle of a dispute with a healthcare plan, this is probably not a bad roadmap for you to follow. And it's almost step by step as to the things that will occur. In here, each step assumes that it's going to take a month. And on the average, that may be about right, but it can often take longer than that. So when I put a 2-year timeline on this thing, yeah, that's if 2 parties cannot reconcile what went wrong in a claim, yeah, it could really take 2 years to actually resolve something. So keep that in mind. Usually right around here, like in year 1, in the 6th, 7th, 8th month, is when people start to kind of wake up to it. And all of a sudden people start to pay attention. And that's really when the reconciling and the negotiating and the mediating starts to happen, is right here around the 7th, 8th, 9th month, somewhere in there. So with that said, I think I've kind of exhausted my whole hour. If anybody's got any questions, I'm happy to take them now. And we'll give it a few minutes, give it a minute. If you have a general question, ask now. Otherwise, Charles will be stopping his recording, and then you can ask your very specific question that you have. Any general questions at this time?
Well, there's a question by Jamie in the box.
Okay.
Ben already answered it. Thank you.
Okay, good. Okay.
Oh, Jamie, thanks for asking that then. So yeah, Charles, if you wouldn't mind just stopping the
Sure.
recording, and let's just make sure that we iron out whatever we can in this discussion.
Okay,
So,
great.
yeah, by the way, for those